Hello everyone. In the last session we have talked about the meetings of the board and its powers. Now we will take it further, and in this session we will talk about the appointment of managerial personnel and their remuneration. So let me just put the topic: appointment of managerial personnel and its remuneration. So there are various provisions from section number 196 onwards. Okay, we are going to talk about that. So before that, okay, we need to understand the various definitions. The first very important definition is key managerial personnel. Key managerial personnel. Okay, so in short we can call it as KMP. Okay, this is a new definition which was introduced in the 2013 Act. Okay, so who all are the key managerial personnel? So there are set of different persons who are the key managerial person in the company. So if we want to just note it down, okay, we can note it down in a different ways. So let's assume that if you want to put it in the so one by one we'll try to understand. Okay, so key managerial personnel, this particular definition is defined under section 2 subsection 51 of the Act, which says that in relation to a company means the CEO or managing director or manager. So the first category of key manager person can be CEO, or managing director or manager, then company secretary, then whole-time directors, then CFO, that is Chief Financial Officer, then such other officer not more than one level below the whole-time director as designated as KMP. Then such other officer as may be prescribed. Okay, so let's try to focus on the various key managerial person. The Chief Executive Officer, who is also defined under the Companies Act section 2 subsection 18. So Chief Executive Officer is defined under section 2 subsection 18, which says that an officer of the company who has been designated as such. Then Company Secretary is defined under section 2 subsection 24. Chief Financial Officer is defined under section 2 subsection 19. Okay, so these are the officers who are defined under the act. Okay, so the first category is Chief Executive Officer, either it can be MD or manager, company secretary, full-time director, CFO of the company. So these are all KMPs. We will talk about the KMP, the corresponding provisions about it. The manager is defined under section 2 subsection 53, and MD is defined under section 2 subsection 54, and manager is defined under section 2 subsection 53. Okay, so these are all definitions of the key managerial person. So one by one we'll try to understand. Okay, the CEO of the company means a person who has been such designated. Who is the managing director and the manager? Okay, managing director means a director who is entrusted with the substantial powers of the management of the affairs of the company. Okay, so by virtue of the articles of association and agreement with the company and a resolution as passed in the general meeting or by the board of directors. So managing director, first the criteria is he has to be the director of the company, and then only he can become the managing director, and includes a director occupying the position of the manager. So basically the managing director enjoys the substantial powers of the conducting and managing the business of the company. So it emerges as MD needs to be a director in the first place, and then only he can become the managing director. So it is not necessary that a director who occupies the position of manager needs to be called a managing director. He may be called by whatever name called, but all the essential features if he is complying with, then he will be designated as managing director. Then who is the manager? Okay, the manager is basically an individual who is subject to superintendence, control and directions of the board of directors, has the management of the whole or substantially the whole or affairs of the company. So and includes a director or any person occupying the position of the manager. So it need not be, okay, manager need not be the director, unlike the managing director who has to be first the director of the company, then only he can be designated as the managing director of the company. So don't get confused, students, because manager over here is not the head of any particular department. So just to give you an example, if a person is heading a department as a manager, let's assume that he is heading the department of the marketing, then he is a marketing manager. Does not mean that manager means that. Here the manager is a person who will have the entire affairs of the company in his hands. Okay, so manager functions under superintendence, control and direction of the board of directors. So he is accountable to the board of directors for that particular purpose. So it is not necessary that manager should be the director of the company. But we will talk about that company may not appoint both at the same time, managing director and manager. Company secretary. So company secretary is defined under section 2 subsection 24. As per that, it means a company secretary has defined under section 2 subsection 1 and subclause C of the Company Secretaries Act 1980, who is appointed by the company to perform the function. So for the prescribed set of companies, a company secretary in employment is required. So the mandatory condition, like if the paid up capital is more than 10 crore rupees. Okay, so at that particular time he is the company secretary. Now there are two types. Okay, one is in employment, one is in practice. So one who is in practice is defined under section 2 subsection 25 of the Act. So who is deemed to be in practice as per the Company Secretaries Act 1980. Now who is the whole-time director? Whole-time director is defined under section 2 subsection 94 of the Act. It includes a director in the whole-time employment of the company. So whole-time director is in whole-time employment of the company. Okay, so who may be having a kind of agreement with the company for being in the whole time employment. Okay, so he is in the full-time employment. He is a full-time employee, we can say, who is required to devote his to full-time, okay, for the management of the company. So person who is not a director in the company cannot be employed as a full-time director. So he has to be first director of the company. Now, who is a CFO? That is Chief Financial Officer. It means a person appointed as Chief Financial Officer of a company. So who will have the powers, or who will head the financial affairs of the company? Okay, that person is the Chief Financial Officer of the company. The fifth category is such other officer not more than one level below the WTD. So who is directly reporting to the WTD, that is whole time director, may be called as KMP. Such other officer as we prescribe. So these are all the KMPs. We are going to talk about their role and their appointment, as well as the remuneration part of it. Let's proceed further. We'll try to now understand the provisions, various provisions relating to this particular chapter. Appointment of MD. I'm going to use the short form. Then WTD or manager. MD, WTD or manager. Section 196. So section 196 of the Act says that it talks about the provisions relating to the appointment of the managing director. WTD means full-time director or manager of the company. So it says that a company shall not appoint or employ a managing director and a manager at the same time. What does it mean? A company shall not appoint or employ a MD and manager at the same time. MD or manager at the same time. So MD and manager cannot be appointed, okay, at the same time, but there can be MD and full-time director. That is not the issue. So what is a tenure? So let's talk about the tenure. What is a tenure? Not exceeding 5 years. So MD can be appointed for a period of exceeding 5 years. It is further provided that no reappointment shall be made earlier than 1 year. Earlier than 1 year before the expiry of his term. So again we can just put over here. No reappointment shall be made earlier than 1 year before the expiry of his term. So can there be a person who can be appointed as the MD for lifetime? Answer is no. So he can only be appointed for a period of not exceeding 5 years, and reappointment is possible but not okay earlier than 1 year before the expiry of the term. Then for appointment for appointment just a moment. As MD WTD manager he shall not be disqualified under section 164. So if you are aware, okay, 164 talks about the disqualification of the director. So he should be qualified enough to be a director in the company, then only he will be eligible to become the MD, WTD or manager. So there is again the age criteria which is mentioned. So age criteria, a person should not be below age of 21 years or has attained the age of 70 years. Okay, so below 21 years and has attained the age of 70. So a person to be qualified as the MD, manager or the full-time director, he should not, okay, his age should be 21 years to 70 years. So requirement of special resolution is there. There is a relaxation in case a person is above 70 years. Okay, he may still be appointed if the special resolution is passed in that particular effect. So explanatory statement will be required to be provided for that particular matter. Further, where no such special resolution is passed but vote cast in favor of the motion exceed the votes if any cast against the motion, the central government is satisfied on the application made by the board that such appointment is most beneficial to the company, the appointment of the person who has attained the age of 70 years may be made. So their relaxation can be given. Then again, he is not on discharge, insolvent or has any time adjudged as an insolvent, or he has not convicted, he has not been convicted, he has not been convicted by a court of an offense and sentence for a period of more than 6 months. Okay, so convicted, he has not been convicted for more than 6 months. He is not undischarged insolvent. So these are some of the criterias. Additional eligibility conditions are given under Schedule 5 of the Companies Act, where it is stated he has not been sentenced to imprisonment for any period, he has not been detained for any period under the Conservation of Foreign Exchange Prevention of Smuggling Activities Act. So and he should be the resident of India. So these are all the conditions which are given over here under Schedule 5 as well. So appointment, we have seen a company shall not appoint or employ MD or manager at the same time. That is the first important condition. At the same time, you cannot have both. Why? Because when the managing director and manager are appointed at the same time, you cannot give the powers, similar powers to both the persons, and that is the reason you cannot have both the persons at the same time. For appointment as MD, WTD, manager, he shall not be disqualified under the section 164. So he should follow, he should possess the qualification criteria as a director, then only he will be eligible to become the managing director, full-time director, or manager. Now we'll talk about procedure for appointment. Procedure of appointment. Section 196, section 196 subsection 4. Approval by board and shareholders. Inclusion of certain disclosures, inclusion of certain disclosures in notice, and then filing of return. So these are three important steps. First, approval of the board and shareholders will be required for the terms and conditions of the appointment of the managing director, whole-time director or manager. Then it will be taken up before the general meeting as well. So certain disclosures have to be made in the notice convening the board and the general meeting. Okay, so where the appointment is to be taken up, it should include the terms and conditions of this appointment, the remuneration payable to such MD, WTD or manager, or such other matters including interest of directors in such appointment should be properly given. After appointment, a return has to be filed, okay, with the registrar within 60 days. So return has to be filed with ROC within 60 days. Okay, so these are the procedures to be complied with for appointment of the WTD, MD, WTD or manager. So you can just quickly note down all these points, whatever we have covered so far. Now we'll talk about the managerial remuneration. The next topic will be managerial remuneration, which is given under 197. But before understanding that, we need to understand the definition of remuneration. What is meant by remuneration? Okay, so remuneration is defined under section 2 subsection 78 of the Act, which defines remuneration as, it means any money or its equivalent given or passed to any person for services rendered by him and includes perquisites as defined under IT Act 1961. Okay, so it means any money or its equivalent given or passed. It means any money or equivalent given or passed to any person for services rendered to him, or includes perquisites, so as defined under IT Act 1961. Now we are going to talk about the managerial remuneration. Overall, what should be the maximum managerial remuneration, and in case of absence or inadequacy of profits also. So 197 says that it lays down the overall maximum managerial remuneration payable by every public company and the managerial remuneration payable by it in case of absence of inadequacy of the profits. So this section 197 does not apply to a private company. So first note we need to mention over here. So this is a note. Section 197 does not apply to private limited companies. Okay, so this is only applicable to public limited companies. So what are the provisions? Overall maximum remuneration. Let's try to understand. Overall maximum managerial remuneration. Overall maximum managerial remuneration. So we need to understand with the help of the chart, okay, what can be the overall maximum remuneration. So we can have three different parameters over here. We can have like this. Can just put over here. Okay, so we can just put over here the serial number, or you can say conditions for managerial remuneration and maximum remuneration in financial year. Maximum remuneration in financial year. So we can one by one we will try to understand. So number one, so condition overall limit is 11% of net profit of company for that financial year. Okay, so overall limit is basically 11% of the net profit of the company or for that financial year. The second criteria is if there is one MD and WTD or manager. If there is one MD, WTD or manager, so at that particular time 5% of net profit of the company for that financial year. So try to understand the net profit has to be calculated, okay, as per the 198, section 198 of the Act. If there is more than 1 MD, WTD or manager, then the limit is 10% of net profits again of that particular company during the financial year. There is one more limit. So I think these three limits I think are enough. So we can just note it down over here. These particular limits. So one has to understand, okay, these three limits. Overall limit, if there is 1 MD, WTD manager, 5% of the net profit. So net profit has to be calculated, okay, as per section 198. Can this limit be exceeded? Okay, so in the general meeting, if the special resolution is passed with the approval of the company special resolution, then it can be exceeded further. Section 197(2) provides that above percentage shall be exclusive of any fees payable to directors under, okay, section 197 subsection 5. So here I can give the note, net profit shall be computed in the manner laid down. So here I have to give the note, net profit shall be computed in the manner laid down in section 198. Now what if the profit is not there with the company? If any financial year a company has no profits or its profits are inadequate, the company shall not pay by way of remuneration any sum exclusive of sitting fee, okay, to its director including MD or whole-time director, except in accordance with the provisions of again schedule 5 for that. So the schedule 5, okay, there are limits given, but we'll not go in so much of details. Students, we will have to, okay, just remember all these particular provisions. How the remuneration is determined? It is payable to the directors of the company including any MD, whole-time director, shall be determined in accordance with articles of association by resolution, and if the articles so require, by special resolution. So we can just write down determination of remuneration, determination of remuneration it may be by AOA of company or you can say by a resolution or resolution passed in general meeting. So if any services provided in the professional capacity will not form the part of the remuneration. There are provisions for the sitting fees. Okay, so sitting fee provisions are also given. What is meant by sitting fees? So when board of directors comes for the meeting, they are entitled for the sitting fees. A director may receive remuneration by way of fee or for attending the meetings. Sitting fees are given for attending the meetings of the board or committee thereof, for attending meetings of board or committee thereof. It should not exceed rupees 1 lakh per meeting. And third criteria is the sitting fee to ID and woman director shall not be less than payable to other directors. Okay, so these are some of the criterias for the sitting fee. So a director may be entitled for the 1 lakh rupees per meeting sitting fee, and for ID and woman director it should be very similar, so there should not be any kind of discrimination made with respect to the sitting fee payable to the independent director, woman director and others directors. Mode of payment of remuneration can be by way of monthly payment, it can be specified percentage of the net profit, or partly by one pay or partly by the others. Refund of excess and everything, those provisions are also there. It should be again given in the annual report of the company. Recovery of managerial remuneration in certain cases can be done. In case of fraud or non-compliance with any requirement under Companies Act and the rules made thereunder, for that particular purpose there can be recovery of managerial remuneration, so that is in certain cases. So with this we have completed the part of managerial remuneration as well. So please make a note of all these points. Now we will talk about appointment of key managerial personnel. Appointment of KMP under section 203. So section 203 read with rule 8A of the company's appointment and remuneration of managerial person rules 2014. There are certain provisions. So every company belonging to prescribed class, So only prescribed companies. Which companies are required? Only specified companies, prescribed companies. So as per rule 8A, as per rule 8A, following companies shall have whole time KMP. Now who is KMP? We already studied. So which company should have? Every listed company, and every other public company having paid up share capital of 10 CR or more. Paid up share capital. Okay, so these companies should be there. Every listed company first of all, and every company having paid up share capital of 10 CR or more. So whole time MD or chief executive officer or manager, and in their absence whole time director, company secretary, and chief financial officer. So there is a prohibition on individual to be appointed as chairperson as well as MD or chief executive officer at the same time. So an individual shall not be appointed or reappointed as a chairperson of the company as well as MD or chief executive officer of the company at the same time, unless the articles of such company provides or the company does not carry multiple business. So how these conditions are what? So requirement of the board resolution, okay, should be there. There are certain conditions for appointment, you can say. So first condition is requirement of board resolution a whole time KMP shall not hold office in more than one company. Whole time KMP shall not hold office in more than one company. Of course, this particular condition is not applicable for the subsidiary company. So he may hold the office in the subsidiary company of that. So within 6 months, okay, vacancy has to be okay filter properly. There are penalty parts given if the company does not fulfill this criteria. Penalty for non-compliance, penalty for non-compliance. So if company does not fulfill the part, okay, then there can be penalty which can be levied on the company as well as on the officer in default. So company or director and KMP. So company, what is the penalty? Of course there should be fine of rupees 5 lakhs. And in case of director or KMP who is in default, so fine of rupees 50,000 okay, plus rupees 1,000 penalty each day of default. If continues, okay, so 50,000 plus penalty of each day of default if it continues. There is a provision for the company secretary's duties under section 205, where the company secretary has to be appointed in a company. Then there are some functions of the company secretaries which are given under section 205. He has to report to the board about the compliance part of the Companies Act and any other applicable law, to ensure that the company complies with applicable secretarial standards, to provide to the directors of the company collectively and individually such guidance as may be required, to facilitate the convening of the meetings of the board, committee and general meetings, to obtain approvals of the board, general meeting and the government and such other authorities. So there are various duties which are prescribed. He has to represent before various regulators, other authorities, to assist the board in the conduct of the affairs of the company, to assist. So he is a kind of connecting link between the board and the various stakeholders of the company. So please make a note of all these points of appointment of KMP. And we'll now talk about the last topic for a day, secretarial audit. Secretarial audit 204. Okay, so there are prescribed companies, only for prescribed companies. Okay, the following types of companies, following types of companies to get conducted secretarial audits. So it is not mandatory for all, but only for the prescribed companies. So which are those prescribed companies? First of all, every listed company has to conduct the secretarial audit. and every public company where rupees 50 crore or more paid up share capital or rupees 250 crore or more turnover. Okay, so for these specified companies the secretarial audit has to be conducted. So company secretary in practice is authorized to conduct the secretarial audit. It should be annexed, okay, with the board's report, and the company is duty bound to give all assistance and facilities to the company secretary in practice for auditing the secretarial and other related records of the company. So any qualification or observation or other remarks should be provided by the company secretary in practice in his board report. Penalty for contravention: any company or officer or the company secretary practice, if we contravene section 204, then they can be liable for 1 lakh rupees penalty, which can be extended up to 5 lakh rupees. So that's it from my end today. Okay, so we have concluded. Very quickly we can go through the provisions what we have done. So today we started with, okay, in this particular session, appointment of the managerial personnel. We try to understand the concept of key managerial person. Who are key manager person? So CEO, MD, manager, company secretary, WTD, CFO or such other persons are the key managerial persons. Then we try to understand the appointment provisions of the key managerial persons under section 196. Then we talk about the procedure for appointment of the key managerial person. Then managerial remuneration, which is to be paid. The remuneration definition we first understood, which means any money or equivalent given or passed to any person for services rendered by him, which may also include the perquisites. Overall maximum managerial remuneration we have understood in the tabular format. Net profit should be calculated as per section 198. Then we talk about determination of remuneration and the sitting fees. It's a very lengthy section, okay, of the Companies Act. Then appointment of the KMP. Then penalty for non-compliance, secretarial audits which are required for specific companies. And the last which we discussed, that is functions of company secretary as well, which are given under section 205, functions of company secretaries. Okay, so we have covered so many topics today. I hope you have understood all these very well. Thank you so much for watching this video. Do watch this video, read the notes corresponding provisions of this Companies Act 2013. In the next session we will come up with a new topic. We have covered so many topics, okay, till date. The major part of the Companies Act we have covered. Company law provisions we have covered along with the important rules, corresponding rules. Thank you so much for watching this video. We'll meet very soon with the new video. Till then, goodbye.